Good afternoon, everyone. Let me start with a sound check. If I'm audible, someone give me a thumbs up, please. Thank you. All right. So we're ready to start. Let me start by welcoming everyone to this webinar and really thanking you all for creating time. It's great to see 64 of you creating time to join us today. My name is Tabo Mogalema. I'm the founder and CEO of Spectrum Analytics. And I would like to thank you for really creating time to attend this webinar on complying with the DPA Act of 2018. And just to set the expectations, really, we would love for this to be an interactive session. So please feel free towards the end. We'll have time for a Q&A session that would be interactive so that we can really give you tips and practical steps that you could take towards ensuring compliance with the coming act. This is the first of a three-part series that we'll do on the Data Protection Act itself. And today, I'm really happy to be exploring the path towards compliance with Senolo Modise. I'll let her say a bit about herself, but before we get there, let me just also do a bit of housekeeping as well. So I'm going to start with like the intros and then we're going to jump into Senolo's brief presentation to set the tone up. And then after that, we'll then jump into the dialogue discussion where we'll also cue you in. We would also have just while other people are still joining because there is still a lot of people joining, we'll just do a bit of like all three questions, just to improve interactions. But then after that, Sinolo's presentation, and then all that. And with that, I think the traffic is settled now, and we can just start. So just to check if you would be able to interact with us, we have about three questions. I will give the first question in. If you check on your, I think it would be on your messages on the chat, you'd find the poll, and then you can just complete the poll and then submit your votes. All right. Then while everyone is still waiting, you may test your connection.
Hey, are you able to hear me?
Yes, although the decibels are a bit high.
The decibels are a bit that high.
Yes.
Okay,
maybe
I'm using my headset.
All right. Maybe. All right. Now. All right. Now, I think it's fine now. So, Senelo, when I was thinking about making the introductions, I didn't know where to start because I realized I've really known you for a long time. And the first time we met, I don't know whether you remember the event. It was a developer community event. You were talking about data minimization. And it was way back. If it wasn't 2018, it was 2019. And you're still talking about this act. So, you're someone I've known in the space. We have met across multiple platforms on payments, on cybersecurity, even on the creation of different policies there as well. So I really didn't know where to start with like introducing you. So I'm gonna give you an opportunity just to share a bit about yourself before then you jump into your presentation itself.
All right. Thank you very much, Teboho. It's a good thing that I'm not introducing myself to you because, like you said, we have known each other for a very long time, and I'm very disappointed that you chose to have me introduce myself instead of introducing me because you know me well enough. But I guess you don't want to misrepresent me. It's difficult having a lawyer for a friend.
Oh, you know.
Yeah. Yeah, I am Sonolo Modise, and I'm a friend of Spectrum Analytics. I specialize in technology and cyber from a legal perspective. It's quite a refreshing look to see technology in that light, and I deal with all issues that are there in technology, be it loss of emerging technologies, the public policy side, anything you can think of that has to do with digitally transforming, ease of doing business using technology. And one of the topical things in that area is data protection. So that's the conversation we're going to be having here today. Thank you.
Ah, thanks for that, Sinola. But just to set the context, we had a point in time where the act itself, even though it's from 2018, last year its enforcement was postponed the year before again, and now this year we had it's definitely going to come. But it comes again at a time when companies now have data sitting across different places, on-prem, in the cloud, and also this data hungry monster that is AI. Everyone is thinking about how to ensure privacy as they adopt these emerging technologies. So I'm quite excited because with all these new developments, it kind of also means we have more to discuss that may not necessarily be on the current version of the act that is out there, is it?
There is something to discuss, but bear in mind that data protection has same themes. The differences would be very, very narrow, distinctive things like the time it takes to report a breach or the mechanisms for transfer. But for most parts of the legislation, it's the same. Remember, it has to be so. It's like constitutions, they have similar themes. So I don't think that we would lose anything from having a conversation now instead of later.
All right. Yeah. So just an interesting thing again, while you queue up your presentation, you have the option to share your slides there. Is it? Yeah. While you are doing that, I was got that back because just when we were promoting this on BTV, I think the day before yesterday, the presenter did say that we as Botswana do not really care about privacy. But I had to remind him that this act itself extends privacy that was already guaranteed. And I did my homework under Section 9 of our Constitution. And it's just extending this into the digital space itself. So I really look forward to your presentation, and then we'll have more conversations after. And for everyone who joined maybe after the intros, feel free to type in questions on your chat. We're gonna give you plenty of time. Most of the time really would be an engagement with you more than us presenting or sharing more. So we really look forward to an interactive session with everyone. Are you able to share your presentation, Sinola?
Yes, I'm able to share. Let me just do that for you. How much time are you giving me to present?
You have about 20 to 30 minutes.
20 to 30 minutes.
Yes.
30 minutes sounds too much for free legal advice.
All right, I will settle for 25.
Okay. Are you able to see the screen
All right.
that
Yeah,
I'm
it's
sharing?
visible.
Okay.
Yeah.
All right. Yeah, thank you very much. I hope you're not seeing anything else because I'm trying to safeguard my clients' privacy as well. So let me shoot right into it so that we don't take a lot of time on this. I am from Bookbinder Business Law, where I lead the technology, cyber, and data protection department. I'm aligned with Teboho to the extent that we wanted this to be an interactive session, a session where you ask questions that you have had in mind, a session where we clarify any position of the law or any likely position of the law. So the way in which I'm going to do my presentation, I only have 4 slides because in the event that you ask me to share the slides, you can get the slides without, seeing too much in terms of what I have to say. And also because it's short time, the presentation will be done for a very short time. So I'm bringing to you the things in the act that you should never miss, things that you definitely need to be aware of. But I will also go towards talking about the practicalities or what compliance would look like. So the first thing is to understand that this act has a scope, and the scope would be territorial, which is where does the act apply? It applies to data controllers that are in Botswana or those that are using processing means that are in Botswana. The territorial scope is important because it informs you why the law applies to you. You should not be an organization which assumes that the law applies to you because you may find that you have no obligations. So confirm that you have an obligation, and it is also important to determine whether you have any other obligation arising from any other law, because the nature of data protection is that you find that other laws will be applicable to you depending on your global footprint. The material scope is to clearly define that this act applies to data that is both electronic and physical, and that data ought to be personal, which is data that identifies an individual. In the organization, you have different types of data, but what the Data Protection Act is concerned with is that which identifies an individual. That individual may be identified directly, meaning that you definitely can see at first instance who this person is. It may also be indirect. Indirect, we mean something needs to be brought, any additional information needs to be brought into the picture in order to ascertain who this person is. Let's say an example. If you were to fill out a form and that form has no name, but it has your ID and your birthday and the like, it has your job description, but doesn't have your designation. That's the kind of data which we will call identifiable. It can identify you indirectly, but if in that form you put a name, then it means all of the data is identifiable. This is important because you must know that the state of data, which is whether it's directly identifiable or indirectly identifiable, it's not cast on stone. Data could keep changing how it represents in terms of identifying an individual. And we are interested in data that is in the data life cycle. That is why there's an indication there that the Act governs the processing of personal data. And if you look at what the processing means in the Act, it is clear that it means collection, it means recording, it means making available. By dissemination, it means storage. So these terms are, indicative of the fact that we are dealing with data that is in the life cycle. This is something that you probably already know from a data governance perspective. So your compliance must not only be focused on the processing operation of collection. It must also be focused on everything that you do, even disposal. You still need to take into account what your requirements are. The stakeholders, the Information and Data Protection Commission would be the supervisory authority. That means that it oversees compliance and it enforces any obligations for enforcement which derives from the Act. And we do have our supervisory authority, and I think some of you may have interacted with the commissioner. This act must be complied with by controllers and processors. A controller being an entity, whether it's a natural person or a juristic person, such as a company, a society, or anything else, that determines the purpose and means of processing. So if you are able to say you are building a solution and you say, I want to collect name, email, and the rest of the information you want to collect, that means you are defining why you want to process it, because there is a reason why you came up with that solution. And then the means, we mean that this solution that you have come up with, which has a purpose, how are you going to ensure that you deal with this data? That is what we mean by means. I'm going to collect using this form. I'm going to use jot form. I'm going to use a survey, like Teboho is rolling out a survey now. I hope that the survey is not collecting personal data. We have subjects, that is who is supposed to be protected by the Act. These are natural persons. The Act has principles, and he asked a question about whether we need to wait in order to appreciate the changes. And I said we don't need to, because principles are the same across the world. Principles which are the cornerstone or fundamentals of data protection are the same. There's usually 7 of them. The last one is accountability, but you will see that I've not written it there. But accountability really indicates that you must be held accountable for, data protection compliance. You must be seen to be complying, and you must demonstrate that compliance to the regulator and to the data subject. So the principles are focused on here is lawfulness, fairness, and transparency. These deal with how open you are about data. And lawfulness, fairness, and transparency, if you refer to the substance towards your bottom right, you will see that I've spoken to information obligations, and that is the level of openness that the Act requires from you. That is where we see privacy notices. That is where we see your ability to account to the data subject what exactly you are doing with that data. With lawfulness is the most complicated principle. It is lawful grounds of processing data, to acknowledge that you have a purpose, but we also want you to have a lawful ground for processing. Those lawful grounds are in the Act. You would see them at section 16 for personal data, and then you'll see them at section 20 and the bottom sections for sensitive personal data. The reason why I say it's complex is it's not easy to map the purpose with the lawfulness. You can choose the wrong lawfulness if you are misinformed, if you don't know how lawfulness works. And you may also choose the wrong lawfulness if you didn't classify your data appropriately, because the lawfulness or the lawful grounds for personal data are not the same as the lawful grounds for sensitive personal data. We have purpose specification and limitation. This is the fact that you have to specify a purpose for processing data. Not only do you specify that purpose, you must do any form of processing within the limits of the purpose you have specified. Purpose specification, the audience is the data subject. It's not yourself. You are not specifying the purpose to yourself. You are a secondary, you are what we would consider secondary target audience for purpose. The primary audience for purpose is the data subject. I should not interact with you in my capacity as a data subject and not know what you are doing with my data. And it's your responsibility to tell me what you are going to do, even when I've come to you for a service. That is what information obligations would require. Data minimization is, simply put, is adequacy and proportionality, is the information that you are collecting relevant for the purpose you would have determined. Is it adequate for that purpose as well? And the point of these is really to ensure that only data which is necessary is collected. And that is where the concept of data minimization comes from. It comes from proportionality and necessity. Information quality is the responsibility to ensure that that personal data that you are processing is accurate, up to date, and is complete. You can have quality issues with your personal data if it is not complete. That is, if you have in your form something that needs to be completed but it's not completed. You can have accuracy issues where you have data that doesn't reflect the reality on the ground. And these quality issues then bring us to the way in which we manage data. It means that gone are the days when you don't properly clean up your data. Gone are the days when you don't have, you don't actively engage with your data to ensure that the quality is desirable. Then there is a retention limitation, which speaks to the level of storage. And when we say level, we mean duration. You have to ensure that data is kept for a duration that makes sense. And it should make sense in the context of the law, if not in the context of the purpose that you are keeping it for. So with retention limitation, take it like an if statement. You have a retention requirement. The law would tell you how long you should keep data. If it doesn't, then consider the purpose that you are using it for. The last one is security safeguards, and all of us data protection practitioners keep this one the last. And if you look at the act as well, it's kept at the bottom. The reason being that security is a subset of data protection. You can have security but still be non-compliant. An easy example is when you have adequate security safeguards, appropriate access control with appropriate level of authentication, then the data that you are collecting is more than necessary. It means that you have a problem with the concept of data minimization. You may have security, but not have informed the data subject what you are doing with that data. Then you are compromising fairness and transparency. So it's important to know that whilst organizations tend to prioritize security safeguards, it does not equate to the safeguards of personal data, because the safeguards of personal data are a bigger creature than security. Security is there to support a certain function of safeguarding personal data. So in terms of the substance, like I say, you have to demonstrate total compliance with the Act. And that total compliance starts with ensuring that all the principles are complied with. This is one area of the Act which non-compliance is prevalent. You have a lot of instances where organizations do not, comply with their obligations for the principles. So make sure that the principles are complied with at all times, and you have a sense of that compliance if you have an appropriate data protection management program. The record of processing activities is a document that you should keep, whether that document is kept in a spreadsheet or any other format. But in a record of processing activities, we expect to see detailed information about your processing activities. I must make it clear that record of processing activity is not the same as data mapping. Data mapping is a task which you do when you complete your record of processing activities. A record of processing activities is, is a document that would identify what business function is collecting that data, what data is collected for that processing activity, um, why are you collecting it? What is the lawfulness? Have you informed? Do you share it with third parties? On what basis are you sharing it with third parties? If you are transferring it outside, on what basis are you doing so? How long are you going to retain it? What's the disposal method? What are the security safeguards? I think a typical record of processing activities has about 20 columns. So it's an area of your responsibilities that you do at the initial stages of your compliance, because the question will always be, when you are drafting the documentation, your policies and procedures, what informs what should be there if you don't have a record of processing activities, and it must be kept up at all times. If you look at our current Act Section 36 that relates to the data protection representative, which admittedly is an unconventional name for a data protection officer, you will see that it specifies that the data protection representative must keep a list of processing activities. It's also unconventional naming. The conventional naming would be record of processing activities, and in the amendment, likely they are going to include all the conventional definitions that are there in data protection. We have the enforcement of rights, which must also be given effect to. Notification obligations, that is where we see notifying for data breaches, notifying if you have carried out a data protection impact assessment and you find that you still have residual risk after implementing controls. Information obligations is wherever you are collecting personal data of data subjects, are they adequately informed? And with information obligations, you are not going to have a one size fits all. It's not possible for an organization to have one privacy notice. There must be as much privacy notices as the channels where you are collecting personal data. You have collection of personal data at reception, there must be a privacy notice. You have it at the website, there must be a privacy notice. You have it when you hire people, when you recruit, there must be a privacy notice. It cannot be bundled, because for each privacy notice, we would like to see what data you collect and why you collect such data. You have to conduct impact assessments. We'll see some of the impact assessments that have to be implemented in compliance with the Act. There's also an issue of transborder flows of personal data, which is not necessarily the issues can you store or not. It means can you move or not, because transfer and residency mean different things. Appointment of a DPO, an organization must reflect on whether there are triggers for the appointment, because it's not a blanket approach. It's not because you are supposed to comply with the Data Protection Act, therefore you must have a DPO. But it's also important to indicate that instances where you don't have to appoint a DPO are so narrow. You'll find that businesses that operate in today's environment where you want to digitally transform, you are not going to be within the scope of organizations that cannot have a DPO. In appointing your DPO, make sure that they meet the requirements of the law. That is, they must be an expert at data protection. They must have the requisite qualifications. They must have a good grasp of cybersecurity, a good grasp of risk management, a good grasp of operations in that industry. So it can be difficult to bring someone in a banking environment, a financial services environment, insurance, when they do not have an understanding of that. If you intend to hire someone who's outside these industries, you have to ensure that you adequately resource them. And resourcing them means, you properly orientate them on how the industry works so that they can be able to discharge their data protection obligations. That is why we see a lot of DPOs who were in the industry then upskill to become data protection officers, because it takes a shorter time for the organization to get the real benefits of a DPO than if they hired. Unless, of course, you are getting a DPO that is just experienced and they will not have a hard time applying themselves to data. So I had a slide, and I would have dealt with everything in the previous slide, but I had this slide so that I can avoid being asked about whether data should not be transferred outside Botswana. It's a question that is at the helm of compliance or at the helm of concerns. It's a pain point for everyone, yet it accounts literally for about 10% of the compliance. Not only that, the fine it carries is different from the other stuff that organizations are ignoring. So with trans-border flows of data, it's a very narrow requirement. And that narrow requirement is informed by these three concepts. That is the jurisdiction of data, which is data sovereignty. It speaks to the fact that data is subject to the law where it physically resides. So if at all data is in Botswana, then it means the law of Botswana applies. So if I have data on my laptop here, the law of Botswana applies to it. That is why sometimes you see when you travel, you must ensure that you don't have data that can be unlawful in that other country. For example, if you have pornography on your device and you go to a country that doesn't allow pornography, God forbid they get interested in your laptop one way or another, you are going to be punished adequately. So data is subject to the laws of a country where it physically resides. And then data localization focuses on the movement of data. When you say transfer, you basically mean movement. Storing is different from transfer. That is why we draw a distinction between localization and residency, because localization is movement, data in transit. Residency is data at rest, which is storing. So in every data protection act, you must find out whether the dispensation is localization or residency or both, because they can both be there. And if you look at our act, which has a general provision on, or rather a general prohibition, and then there's exceptions to the prohibition, it is indicative that there is conditional localization. You can transfer, but I require you to do this. Now, with residency, you also will see it in the act, as a data protection professional, and the reason why a DPO must have both a legal background and a technology background is you must be able to interpret statute. We don't expect a DPO or a privacy practitioner to be asking, can we store data locally or can we take it outside? Because the question becomes, did you not interpret the law? Yes, you can have a political conversation or a regulatory conversation or expectation from the supervisory authority. And when you have such expectation and the supervisory authority expects you to keep it in country, and then the law says one thing, you treat it with, utmost diplomacy. You don't say, well, the act says we shouldn't keep data in country, so I'm going to transfer it. And you also don't get scared and say, oh my goodness, we have to keep data in country. You have to apply your mind to it and see to it that you can find a sweet point a compromise, because the regulator is in a position of power. They can wake up tomorrow and amend the law to represent what the expectation that they've been having is. So it's important that you navigate it with a certain level of diplomacy to say this is where we are, but we acknowledge that the law could change, even though that at this moment it's not. It could change, and what are we going to do? You manage your risk. So I think I urge everyone who is in this meeting to go have a look at section 48 and 49 and answer the question, do you have to keep data in country or not? And then that should be your answer to this question. By the way, the problem or the fine that comes out of this issue is not necessarily that you transferred what we have experienced. It's that you transferred using the wrong lawfulness, using the wrong legal basis. So if in Botswana, for example, we have section 48.2, section 49, and then section 48.2 is a whitelist, section 49, 1 and 2 is adequacy decision, section 49, 3, 4, and 5 is derogation. Section 49, 6 is appropriate safeguards. So those are the mechanisms that are there. It's possible that you can choose the wrong mechanism, then it becomes a problem. This is what happened to Meta, to Facebook, when they transferred data to the US and they were fined 450 million euros last year. It's because they chose the wrong legal basis. They used a framework that was outdated, which is the Privacy Shield, and the court had overturned that Privacy Shield. So you have to follow the trends of the law. If today we have section 48 and 49 that allows localization, tomorrow we can have something else, or one of the provisions could be cancelled. So it's important to follow the trends to see to it that you take care of lawfulness. That is why I was reflecting earlier that lawfulness is the problem. Lawfulness of processing from any other context, lawfulness of processing from transfer perspective. So in terms of what we want to be able to see, when you tell people that to comply with the Data Protection Act, you need to have a data protection management program. Look, the terminology doesn't matter. You can call it you can call it data protection management program, or you can just call it your compliance documents. But what we expect to see at the basis, at the basic, is these key policies and procedures. Your data protection policy, you have the external and internal one. External not meaning you communicate it outside, but it deals with external stakeholders like your customers and any other external stakeholder. Internal, we could mean it deals with how you handle the data of employees, of board of directors, and any other data subjects that are internal. You need to have a breach notification policy and procedure, a way in which you enforce rights of the data subject, and all of the rights must be within this policy. How are you going to give access? If someone says something is not correct, how are you going to rectify? If someone says they want deletion, under what circumstances could you do? Could you, delete? So those things need to be systematic. We shouldn't decide as and when they come. A transfer impact assessment is also a procedure that needs to be there. When you ask yourself that question, can we transfer data outside or not? That question must be answered by a transfer impact assessment. It's a risk assessment carried out to ascertain the legality of a transfer. It's an assessment that during the course of compliance right now, you must carry it out, because you may have transfer that is ongoing and you have to ascertain that it's okay. We have, you need to have a legitimate interest procedure. You have to have a procedure on inventory of processing activities. This is what becomes the ROPA. a privacy impact assessment, data protection impact assessment. Yes, there's a difference between a privacy impact assessment and a data protection impact assessment. One is required by law and one is just a risk management tool, which you have the option of using. Vendor risk management needs to be taken care of. The way in which you disclose data needs to be managed. And where there was a repetition there on impact assessments procedure, I think at that time I was already thinking about breakfast. It ought to have been consent mechanism policy. I see that Teboho is looking, is zooming into the screen. I guess you didn't pick it up. So the last one, which is often ignored, is the pseudonymization and anonymization procedure. How are you going to de-identify data? Who will de-identify it? Under what circumstances will you de-identify it? Because if you want to reduce your risk, you want to reduce your burden of compliance, there is no way you are going to do so without pseudonymization and anonymization. The difference between the two terms being that pseudonymization, you de-identify with prospects of identifying later. Anonymization, you de-identify forever. So what becomes important, you'll see that these policies, well, a few of them, because I've not yet met an organization that has all of them yet, except those that may be, transitioning. But even those that transition, usually some are left out. But the challenge with these policies could be that the governance framework within the policies, which is supposed to be entrenched in the policies and procedures, is inadequate. We need to be able to see. So this is not in relation to any particular procedure. It's just to reflect what a RACI would look like. We have to see who is responsible for that policy, who owns it, who would be accountable, who's to be consulted, and who's to be informed. If you find yourself having a policy that is unable to speak to these things, then it means we already have a governance problem. So I think that I managed to stick to your time with just a minor modification, which is 5 minutes lateness. I think it's within an acceptable range. But thank you very much.
All right. Thank you very much, Senelo. I don't know whether you spoke to the risk assessment metrics there. You still have I can allow you to go over that one.
Yeah. Well, I didn't speak to it because that is an organizational decision. If you look at the frameworks for compliance with data protection, in these like more than 20 of them, NIST being one of them. I say NIST because many people are familiar with NIST. There's ISO, there's the ICO accountability framework. Whatever you choose can specify a risk matrix, or you could even come up with one yourself. Organizations, because they already deal with risk, could have a risk matrix already. So that's not something that we need to deal with in the context of data protection. It's in the context of any kind of risk you manage.
All right. Cool. But then again, Senelo, another issue that maybe while we're still here, you could also expand on is we're seeing the increasing adoption of the cloud. And we know that when we say the cloud, it means data being stored in data centers outside our borders, being processed in data centers outside our borders. What are the, when you qualified the legal basis for transferring data, the cloud is covered there, right?
Yes, the cloud is covered. But the reason why we conduct an impact assessment is there should be an answer to exactly where. What is the destination country? We can't just say cloud and not know where the country is, because the country then informs you the legal basis you are going to use.
All right. So like right now, if I'm to store some data there, the act itself does stipulate countries that I'm allowed to store data in, right?
Come again, please.
All right. So in terms of jurisdiction, the locations, there are certain locations where it's okay to run applications in or to store data in, but certain areas again are prohibited as well.
Okay.
And
yeah.
The reason why I ask that is I got asked that the other day relative to keeping, let's say we keep data locally and then we want to maybe with everyone playing with AI, we also want to play with some AI, but then the data may be local, but the processing is outside. So in there, does it matter where the specific cloud is kind of sitting, because they sit across multiple regions as well? I think that's the point I really wanted to bring out.
Okay. So yes, it matters. Remember, when we say transfer, we mean it's going somewhere. There's a source and there's a destination. If there's 10 destinations, in the impact assessment, we must still address the 10 destinations. A different legal basis may apply to the 10 destinations. Let's take an example. If you have South Africa, and then you have the US, Australia, Ireland, all of these bases needs to be established. One may be whitelist, the other may be derogations, another may be appropriate safeguards. So if you have that challenge, you need to address it in your impact assessment.
All right. So I hope the IT guys here would see why it would also affect the regions they choose for storing data and all that. But then again, similarly, the compliance and privacy does not just in here in Botswana like affect our DPA alone. We have people of European extraction from EU here. How are the local businesses affected when they process that data? Is the DPA sufficient, or do they also need to extend the coverage to compliance to the GDPR as well?
All right. So in terms of to what extent you need to be dealing with the GDPR, can be answered by the territorial scope. The territorial scope of the GDPR being that it applies to, or in the context of processing that occurs in the European Union, and in the context of processing that is targeted to European Union residents, and in the context of processing where European Union law applies outside the European Union. So there's an EU office in Botswana. In that EU office, the GDPR applies, even though they're in Botswana. So they comply, they may comply with both the DPA and the GDPR, but predominantly the GDPR because of the way public international law works. The fact that, you can have a diplomatic mission and the law of the country where the diplomatic mission comes from is applicable. And I wanted to deal with that first so that I can address the other two territorial issues. So the one that you should be concerned with, if at all you are dealing with the data of European residents, is to find out is the targeting criterion, are you within the scope? Because we are not just meaning, having a website and then people in the European Union use your services or they do an inquiry. There's a requirement that it's clear that you are targeting. Let's say you have a solution for Google Maps. It's used in the European Union. Clearly, you are targeting European Union residents one way or another. So if you're in Botswana and you are targeting European Union residents, whether they are resident in the European Union legally or otherwise, then that is when you have to comply with the GDPR. But it's not a blanket compliance. You really have to find out if there's any need for compliance.
All right. So I think before we go on to the question, I see there are a few here. In terms of when you deal with companies, Sonelo, because for us from the technology point of view, we tend to think about, all right, how can we leverage technology to simplify the process and all that. From a legal side of things, where have you seen, like, where are the sticky points that you have identified as you interact with, like, different stakeholders?
Okay, all right. I actually will answer that question in the context of the poll because I see the progress there. And I'll answer it from I see what the top priorities are. I wish it was a hierarchy so that people can we can see what the second priority would be and the like. But what I find is that there's a lot of emphasis on training and awareness. There's actually over emphasis on training and awareness. And I say training and awareness because most of the training is for purposes of awareness, not for tactical training. Tactical meaning you are training these people to come and uh, come up with a framework for compliance. You are just having a conversation with them. So most organizations organize conversations like this. It may be all day. Then, I guess it's a tick box exercise or however, then they are of the view that they can proceed forward. But for me, what is top priority is process improvement. That process improvement must relate to the policies and the procedures you have set out. The violation from data protection is not going to be that your policy had a problem because policies are public relations type of documents. We aspire on them. We're going to do this. This is the target. These are the objectives. But the processes are the ones that are going to show the inadequacy of the framework. So I'd say process improvement, then legal interpretation. The law will constantly change, and your processes must be informed by what the law requires. Training and awareness, it should be strategic. Train, certification training for some of your team members, because certification is only through certification training that you can have the independence of complying with the act. Tactical training at the beginning of the compliance for privacy champions or people within each business function who will feed information into the compliance journey. Then awareness, enterprise-wide awareness would come later, including the awareness that you give to your board of directors. Of course, with the board and the exec, the awareness must be at the beginning and at the end. So it depends on the audience when it comes to training.
Right. So, yeah. We do have a question. Unfortunately, it's not writing names. It's an unknown user, but the user may just give me a thumbs up. So the question goes like, you have a system processing all the personal identifiable information here locally, and all the data is resident in Ireland, as most of Microsoft products in Botswana utilize Ireland data centers. So all my PII is processed locally and sent for storage in Ireland. What does the Act say about that?
Okay. The Act says you must get a lawyer to come and interpret. So what that means is the issue of transborder flow of data. I like this question because it goes back to my point that a conversation like this means you don't have the proficiency for compliance. I'm not saying conversations like this are not good, but there's where they fit. But it means that carry out a transfer impact assessment, find out if Ireland would be within the confines of the law. Looking at Section 48 and 49, of course.
So essentially, the long and short of it is, if there is any storage or processing elsewhere in any place, that place needs to be one of the places that we are allowed to store or process data in, should it leave our borders, I guess. Then the second one again is, I wonder if it's a continuation, but the Act does not have specific provisions dedicated solely to cloud solutions. The general principles and requirements of the Act apply to any data process, or I guess it's a comment, apply to any data processing activities, including those conducted through cloud services. I guess that was just maybe to answer the first one when we were still not looking at the chat. So everyone, please feel free to interact. You can raise a hand and unmute yourself. All we want to do is to get you to ask questions so that we also learn what some of your challenges are. But if I'm to share something from us as a technology company that we have seen, Senwelo, and is that companies don't have an understanding about their data first. They don't know where that data sits. They haven't mapped that data, classified it, which data is sensitive to the business, which one has personal identifiable information, so that they can see who has access to this type of data and then apply appropriate interventions depending on the type of data that they're holding. And with organizations now more than ever also thinking about data innovation, be it business intelligence, be it data analytics, machine learning, or AI, it also adds a second layer, because at that level again, when we transfer the data to wherever it's being processed, are we anonymizing the data enough? I've seen that these are conversations that are not being had within organizations. Can pseudonymization be sufficient? Again, which one should they choose and why? So in that context, I see that organizations really struggle mainly with the life cycle management of the data itself. From the moment they collect it, I see that when they collect it, most organizations over collect information. So the principle that you shared around data minimization, I've seen it to be a problem. Sometimes I ask on some forms, why do you need this specific information to assist me, to offer me a service? And then from then on, where it's stored, is it stored in secure places? Like you said, security is just a layer that guarantees privacy protection as well. Then the next thing then is, if you look at the entire life cycle management of the data, organizations have gaps from generation to where it's stored to archiving, and with insufficient, again, disposal kind of mechanisms in place. So in terms of where we are, Senwelo, with our digital transformation and having a lot of processes being manual and paper-based, how do organizations how should they think about compliance from information that is sitting on digital technologies or on electronic devices, and then information that is kind of sitting on paper? Should they do a different kind of topper, or the same thing can then clarify whether the data itself is physical, and then whether the data would be captured in a manual sense? Is that something that DOPA can help them address?
All right. So the one thing I want to emphasize before I answer that question, and I hope there is a lot of technology people here, is that the record of processing activities is a multi-stakeholder process. It's very dangerous to involve lawyers only, and it's very dangerous to not involve someone who totally understands data, someone who's able to actually identify physical data and decide whether you are going to put it in a system. But even in the systems, where is actually the data? and also what kind of data that you want. Most systems that we see today are still unable to properly identify the difference between personal data and sensitive personal data in the context the law requires. So I think that, people that deal with data are very crucial for the record of processing activities. When I do a record of processing activities, I will always involve someone that deals with data. I can be able to document the legal basis. I can be able to document, some of the things that would be involved, like transfer impact assessment and all those things. But I feel like it's always ill-advised to do it without the data person carrying out the impact assessment. So I do think that where we are, it's important that the way in which we handle data becomes better, especially during the compliance journey.
All right. Let me see if we have some questions. Please, let's interact. You can only get 90 minutes of free legal advice once in a while. So let's make use of Senelo's presence here, and you can even pose technology-related questions to us as well. So how about this, Senelo? From because I sometimes think of this as a triage of technology, people, and processes. So I think you've touched on how if organizations want to comply, they need to take more like a multidisciplinary approach throughout the organization and not localize it to IT, which I've seen sometimes is where things are then started, or on the risk assessment side, which is where again the different technologies, as it is in our country, you'd find that people who speak the business language more often than not are limited on the IT side, and then on those who are on the IT side and our developers, those who build applications that collect the data, they are also limited on the legal understanding side of things. So with this quagmire, when we speak of a data controller, it's not an individual. It can it be that entire group, or it has to be highly specialized and to a few?
Okay. A data controller can be an individual if that individual is a sole proprietor. And in the context of organizations, is the organization itself, not singular people. It's like the concept of processor. We don't mean individuals within the organizations that are dealing with data. We mean third parties, like your vendors that are appointed to carry out any service which would rely on personal data.
So in that instance, teams should really do their level best to ensure that they involve different stakeholders who work with data, either from the side of its collection, its storage, its processing, and just its governance as well.
Yes, that should be so.
So, I don't know whether there are any questions on the chat that I may have missed. I'm not seeing any questions on the chat, Senelo. I don't know whether it's because you really did a great job explaining this, or let me see who I can pick
I
on
can only hope
here that I know. Pardon? Hello? Am I still?
Yeah, no, you can. Yeah, we can hear you.
All right. Thanks, everyone. I think the Q&A is open. So at any point, please feel free to ask a question. You are free to also just unmute yourself if you also want to interact with us. So we are at that point where we are open to that. But in that sense of that, Sonolo, you know, me and you, we always speak at length. We can take hours talking about this. And I've just been really thinking about something that I know, you know, from a data point of view, like from the moment it's generated all the way until it's disposed, how critical is it for organizations to have an end-to-end kind of visibility of that data and its risk level at any point?
That is very key. That is why the law prescribes that you have a record of processing activities. The idea there is visibility. So there must be end-to-end visibility. Imagine I come to the organization and say, I want access to my data. Without visibility, that access will not be granted. So the record of processing activities is there for visibility. And the law acknowledges that there shall be no appropriate compliance with data protection unless there is visibility of data to the organization and to the data subject.
All right. We have a comment. I don't. Let me just read all of it just so that I don't butcher the insights there. Very insightful, Teboho and Sinelo. Mine is a comment. It's evident that there is a lot of work to be done, not only to be compliant for compliance sake or fear of punishment, but to realize the benefits of data protection in general. This is an integral part of the digital transformation we espouse daily. So let's invest the energies and, more importantly, the resources needed to achieve this. Yeah, I really love that, Thabang, because, Senelo, more often than not, we speak about compliance with the Act from a position of this, a negative position, from this is what may happen to you if you are not complying. Where are the opportunities? If we were to reframe this from a positive point of view, where should we be seeing opportunities in complying with the Act itself? Do they exist?
Yes, there are a lot of benefits. It's unfortunate that we should be compelled to have different data management practices. But for me, the primary opportunity is for organizations to have visibility on that data. Having visibility means you can even manage cost because you will find out that there's data that you can go without, you don't have to pay, all that storage space that you are looking for. It also means that for someone who is in the development space, there's a lot of opportunity to develop solutions that automate this. It's important to understand that clients like to ask, is there a tech solution that I could use for this? There is no end-to-end tech solution. There's tech solutions that can help with specific procedures. And the good thing about law is it's jurisdictional. So a solution that you get outside may not be reflective of the legal requirements here. So it's an opportunity for anyone who is interested to automate the processes or the procedures that need to be there. Another opportunity which I see is that you find that it makes it easier if you're an organization that needs to comply with the Financial Intelligence Act to comply with it because you already have the right KYC, and you can even emphasize your need for KYC constantly because the Data Protection Act requires information quality. I see it as an opportunity for IT professionals to be taken seriously because there is liability that arises from not taking them seriously. I see boards being able to approve better budgets for information technology and security. I see a bit more visibility on those issues to the top. So I think those are the benefits that come to my mind.
Yes. So again, we had a point where everyone realizes the benefits of data. We read and see what digital transformation really is doing across all industries. And the digital economy itself, the way I love to coin it, is that the key mineral in this economy is data. So for me to add to your words, where opportunities are, if you have full awareness of the kind of data that you are holding, then you are in a better place to also come up with informed data strategies. I struggle sometimes when we interact with organizations because they'll be talking everything else related to data innovation. They'll be talking about how they're using data for reporting purposes, how they're thinking about leveraging data for specific AI use cases, as an example. But then when you ask, do you have a data strategy to really first set the tone of how you organize, what kind of data you have, how can you use it, where can it add value for you? So I also think this step is an opportunity for organizations to start from a very good position, just a data discovery assessment for them to end up also creating data strategies which can allow them to really derive value out of the huge volumes of data that they are already have generated and that they are holding on to. Another area for me, again, where I see opportunity, it's again to the total cost of ownership. Within most organizations, I've seen that organizations have a lot of duplicate data. So if you haven't mapped your data, if you haven't assessed your data, you may find that you are holding multiple copies of the same thing, and also you may even be at risk again of data breaches, which can lead to other fines outside just what is within the act. And even in being able to sufficiently come up with strategies around ransomware, if you don't know your exposure level at the data storage level, you are also not in a good position to proactively manage that there as well. So those are just some of the opportunities that I've also seen. And I see we are having a busy chat. So on the chat, there is a question from a data subject perspective. What should we be on a lookout for when we give our personal identifiable information to organizations? I think it's a Kesero Pay.
Okay. Be on the lookout for a privacy notice. Be on the lookout for what the organization communicates to you when they are doing the collection. But most importantly, pay attention to how they say they're going to enforce your rights. And actually, that you have the rights, because you can interact with an organization that will not communicate that you have a right to access. They will not communicate that you have a right to rectification, and that on its own is a contravention of the act to not communicate right. So look at demand a privacy notice, demand that you be told what the purpose of collection is, demand that you be told what your rights are and how you can enforce them.
So are you saying once this is enforced, these big books that we find in most public offices, I should refuse to give them my information unless they can show me some document that shows how they're going to use the data.
Refusal is a difficult concept to deal with in the context of accessing a building because
Right.
there will be detriment from refusing. But when you say refuse, it presupposes that the lawful ground for giving that data is consent. The person at the receiving end or the organization at the receiving end of your data could be using another legal basis, like they are pursuing their legitimate interest. They want to see everyone who comes in or they want to do it for security. So it's not always the case that an organization will opt to choose a lawful ground of processing that requires your active participation. But what I can say is a book like that is inherently a contravention because there is no confidentiality. It is also inherently a contravention because more often than not, they collect more data than is necessary. So those books have a confidentiality problem. They also have a data minimization problem. They also have a purpose specification problem, because if you asked what exactly are you doing with this, it's never clear what the reasonable purpose is.
All right. There are still more questions here. Are there any services that Spectrum offers that can help organizations comply or manage this sensitive data? All right. I think this one you'd be taking a breath. I'll take this one, Senator. So yes, for us as an organization, we recognize that understanding data is the first step towards compliance or informed compliance, and it really also simplifies the process there as well. So we do have a professional services that we run. We have a tool that can be used to scan data that is stored on any environment, on premises, or in any cloud, AWS, Google, Azure. It can scan data wherever it sits. And then what this solution does, it's able to create a map. This is where your data sits. It also classify the data according to your business rules. So you can encode your business rules, and then it would show you which data is sensitive, has personal identifiable information, or according to your rules, which data is sensitive to your business. And it also show you the access rights to that data, where it's sitting, and the settings around its access. How open is it? And then given that, who can access that data? And it can also then also show you, since you stored the data itself, when was the last time it was accessed? Is it frequently accessed? Because that's what we call the data temperature. That is important because if data is generated and never looked at, like Senolo earlier on said, it's data that you can afford to do away with, which would also lower your storage costs, because wherever you store data, it has a footprint, it's occupying servers and all that, and you're already paying for that. So understanding data, we call that we can also run that with you as a workshop. It's a data discovery workshop. We can come in within 30 days. We can provide you with insights on where any document, even on a document, if you have an ID, a bank card, it doesn't matter. All we need to do is to know which fields you classify as personal identifiable information. We are able to pick that on databases, on stores, on even on letters. So I could be submitting a letter to a bank asking them to provide me with a specific service, and then it's stored maybe on OneDrive, on an employee's OneDrive. We can scan all those and show organizations where all that data sits. And from then on, knowing that data, they can then group it, classify it, group it, and then build interventions that are informed by those insights. That's our recommended first step. And again, we do collaborate with Senuelo quite a lot. Like she said, we come from the technology side. She brings the legal side of things to ensure that from this step, then organizations can then start now completing the DOPAs, knowing which data they're holding for what purposes. And I think if you scan your environment, you can then just be able to ask questions that can lead you towards most of what Sinola shared. Should we be holding this data? You'd see it. Who should be accessing this data, or should we even be holding this, and how can we ensure that the data that we have is only accessed by people with the right level of clearances? that's the first step that we recommend to everyone, and we'll share more information after the webinar on our data discovery assessment services. We can run workshops there as well. And then for those who want to be on compliant mode full time, the same solution can be deployed to ensure that you get alerts, notifications, and different types of responses that you may have should maybe data that is too sensitive, someone attempt to access it and all that. So for us, we leverage artificial intelligence itself to do all that, so that just looking at our poll, I see that 54% of those who submitted the views there say they're still doing things manually. It may take you forever if you are holding, let's say, petabytes of data or terabytes of data to just painstakingly go manually through everything that you are holding. And the entire process, we can really cut it down to within a few hours, you can know what's happening in your environment and all that. So those are just some of the services that we do provide specifically to Data Protection Act compliance, as to assist organizations with just simplifying the process itself. I think we are almost towards the end. What we will do is there are a couple of questions, those that maybe we may not be able to address. I would follow up and address them, but we'll take as many as possible from here. I'll take the one by Ufile. He's asking, in light of the restrictions on the transfer of personal, I think it's data from Botswana to other countries under Section 48 and 49 of the Act, can you elaborate on the practical steps we need to take to ensure compliance, particularly when dealing with internal stakeholders and service providers who may not meet the adequacy standards? That's a legal one, Senwelo.
Yes, that's fine. So there is no debate about it. There shall be no sending personal data to a country that has no adequate safeguards, and that is the standard across the world. That's where the law prescribes what adequacy would be. So if you don't fall under Section 48.2, you don't fall under Section 49, you will have a problem. And even 48.2, the one with the whitelist, it must be borne in mind that it's not absolute. A data subject is allowed to go to court and remove any country from that list if they are of the view that there shall be no adequate safeguards. But also what becomes important is, as you relate with vendors that are international, make sure that the law that you have to comply with is reflected on that contract. Stay away from a contract that is template based and you are told the law of some other country applies and yours doesn't apply, because your obligations are here, not necessarily in that other country. So emphasize that your data protection clauses that reflect your reality are in there. And in addition to picking the right legal basis, you must outline the protections that you require from the other side. So here's the idea behind adequacy everywhere. Data must be transferred to a country that has proper enforcement. So if at all Botswana data is being sent to Ireland, there must be comfort that if I exercise my rights in Ireland, then I can be given redress. So if you find yourself sending to a country that doesn't have effective enforcement, it means your level of risk will be high. But take care of the legal basis, but also emphasize contractual clauses that reflect your reality.
All right. Yeah, I think then there's the last one that we'll take. How about compliance with your HIPAAs? Industry-specific regulations say that are also kind of alluding to the same kind of safeguards, like HIPAA for healthcare. I think there's also PCI DSS in the payments landscape there as well. So the question there is, okay, when it comes to I guess the question is, how should companies or organizations think when they also need to comply with other secondary policies or policies?
May you come again?
So
I don't see it on the chat.
I tried to summarize it. It's quite a lengthy one,
okay,
but
okay,
I
just
understood.
Summarize it.
Yeah, I understood the gist because it's like, let me go to the question part. On one hand, we have other data governance being issued on the side by, yes,
okay,
that one.
I see the question. Okay.
Yes.
In terms of rewriting the act, rewriting it just means improving it's how strict it is. It's not going to be rewritten to relax it. The expectation is you deal with any other obligation that arise from any other legislation, and that obligation, if it's personal data, then the Data Protection Act reigns supreme. But what you will find is all the other industry-specific requirements would give effect to the Data Protection Act. For example, you have the cybersecurity guidelines from the Bank of Botswana. If you look at them, they incorporate what the requirements would be in terms of security safeguards required by the Data Protection Act. If you look at the e-health strategy as well, the idea is to incorporate the Data Protection Act. So compliance with other laws. I want to emphasize this. There is no law that you have to comply with if you are not in the territorial scope. A law like HIPAA, there's no basis for complying with it when you are here in Botswana. Because remember, the first thing is that the US is a federation. You find that the HIPAA doesn't apply to other states in the US. So when you think about laws that are applicable to you, find whether the territorial scope applies, but also know that the law will unlikely have inconsistencies. If it does have inconsistencies, the Interpretations Act is clear on how those inconsistencies should be resolved. So most of the time, that is not a bottleneck that we see being an impediment.
All right. I think we have come to the end of our webinar, towards the end. And let me first, Senelo, thank you very much for sharing your knowledge for free. I know you in the legal space, you guys run your meters by the minute. So thank you very much for really agreeing to be part of this webinar. And for everyone who's attending, like I shared, this is the first of a trilogy of semi-webinars that we are going to host on this specific topic. Today, we were looking at the tips and practical steps that you can take towards compliance. The team would announce again then the next webinar when it would be. And thanks everyone again for your participation, for all the questions. These allow us to learn from one another. And most importantly, thank you to my team. For everyone who may want to get additional information, you can follow us on social media pages, Spectrum Analytics on Facebook, on LinkedIn, on Instagram, I think. And, we would engage post this, especially for some of you who have not yet started, to just understand where the challenges could be and see what we can do together. And with that, everyone, thank you very much and have a great day. Bye-bye.
Thank you.